I want to bring in NBC's justice reporter, Ryan Riley. Christy Greenberg served as deputy chief for the SDNY Criminal Division. She is a former federal prosecutor and an MSNBC legal analyst. Paul Butler is a former federal prosecutor and MSNBC legal analyst. Lisa Rubin is an MSNBC legal correspondent. Thanks to all of you for scrambling here. Ryan, give us the latest.
Yeah, so I'm just going to read directly from this filing here. This is something that I think was widely expected that Jack Smith's team was going to file to dismiss these charges. And let me quote from the document in here. After careful consideration, the department has determined that OLC, meaning the Office of Legal Counsel within the Justice Department, has their prior opinions concerning the Constitution's prohibition on federal indictment and prosecution of a sitting president apply to this situation, and that as a result, this prosecution must be dismissed before the defendant is inaugurated. That prohibition is categorical and does not turn on the gravity of the crimes charged, the strength of the government's proof, or the merits of the prosecution, which the government stands fully behind. Based on the department's interpretation of the Constitution, the government moves for dismissal without prejudice of the superseding indictment. The government has conferred with defense counsel, who does not object to this motion. So basically what they're saying is that we had a really solid case here, and we would have gotten this over the finish line but for Donald Trump being elected president and inaugurated. But now they are banned from moving that prosecution forward. So I think pretty strong words from Jack Smith's office there, standing fully behind what they have alleged against the incoming president of the United States, saying that that would have been a very strong case. And obviously, you know, they wouldn't have brought it to indictment if they didn't think that they could prove beyond a reasonable doubt to a jury of Donald Trump's peers that he had indeed committed 4 felonies during his effort to overturn the 2020 presidential election, which all led up to the deadly attack on the U.S. Capitol. Chris.
Okay, Lisa Rubin, I think you're reading it on your phone. This literally just happened, so we're just getting or printing copies of it. But I think before we get into the details of what's actually in it, I want to ask you the question that most people have. Is this case thus dead forever?
Yes.
It's done.
It's done. And in particular, they're asking, well, let me give a caveat to that, because the last sentence says the government respectfully moves under Federal Rule of Criminal Procedure 48A for a dismissal without prejudice of the superseding indictment. So let me try and translate that.
Please.
A dismissal with prejudice means you are dismissing the case and you cannot bring those same charges again. A dismissal without prejudice leaves the door open to charges. However, the charges that were brought here, Chris, unless I'm not calculating it correctly, many of them, if not all of them, would reach a statute of limitations during the Trump presidency that is about to come. So when they are saying that they are moving for a dismissal without prejudice, yes, the Department of Justice seems to be leaving a door open for itself, but I'm not sure that's a door that they can open again after the conclusion of this presidency.
I want to play part of what Jack Smith said last year, just to remind folks, after he filed these charges against Donald Trump.
The attack on our nation's capital on January 6th, 2021, was an unprecedented assault on the seat of American democracy. As described in the indictment, it was fueled by lies. Lies by the defendant, targeted at obstructing a bedrock function of the U.S. government, the nation's process of collecting, counting, and certifying the results of the presidential election. The men and women of law enforcement who defended the U.S. Capitol on January 6th are heroes. They are patriots, and they are the very best of us. They did not just defend a building or the people sheltering in it. They put their lives on the line to defend who we are as a country and as a people. They defended the very institutions and principles that define the United States. Since the attack on our Capitol, the Department of Justice has remained committed to ensuring accountability for those criminally responsible for what happened that day. This case is brought consistent with that commitment, and our investigation of other individuals continues.
So, Christy, tough question, I think, because it's both legal and sort of big picture philosophical. Understanding that Jack Smith very much wanted and push to defend the Constitution of the United States, defend free and fair elections in the way that they are laid out in our democracy, and understanding the vested interest the American people have in that, and the very personal interest the folks he just talked about, the people who tried to defend and defended the Capitol on January 6th have. Did he have no other choice?
I think, in effect, that's right. I mean, if he had continued up until Donald Trump's office, essentially the new AG would seek to do this exact thing, dismiss the case. So in order, I think, to conserve resources, it made sense for him to do what he's done. But just an additional point to what you and Lisa were just discussing. So in this motion, Jack Smith says that, yes, the Constitution requires dismissal in this context, consistent with the temporary nature of immunity afforded a sitting president. It doesn't require dismissal with prejudice, and then goes on to say immunity from prosecution for a sitting president would not preclude such prosecution once the president's term is over, or he is otherwise removed from office by regulation or impeachment. So there is a possibility here that potentially he could be prosecuted down the line. There's a real question whether or not the statute of limitations would be told, because he actually cannot be prosecuted for this period of time. But the real question for me will be whether or not, when the new AG comes in, it's not clear if Judge Chutkan will actually rule on this motion right away, or if she will wait for the new AG, who may take a different position and may say this should be dismissed with prejudice, meaning then it's completely over. There's no way to bring this back after he is done with his term. I would expect that the new AG would have a different take on this and would want this completely gone. The fact that Jack Smith kind of left the window open here, I think, is interesting. It's also interesting to me that I believe, and somebody can correct me if I'm wrong, that this is unopposed. This motion is unopposed by Donald Trump's counsel. And that's significant because his counsel is going to be the number 2 and number 3 at DOJ, assuming that, at least with respect to Todd Blanche, that he's confirmed. So the fact that they haven't opposed this, I think, is interesting as well. Maybe it suggests that they're comfortable leaving this window open because they really don't think there's any way this could ever be resuscitated after his term is over.
Lisa, I want you to pick up on that, because reading this with my eyes, not a lawyer's eyes, but on the first page, he comes to the conclusion that the department, meaning DOJ, has determined that OLC, that's their Office of Legal Counsel, prior opinions concerning the Constitution's prohibition on federal indictment and prosecution of a sitting president apply to this situation, and that as a result, this prosecution must be dismissed before the defendant is inaugurated.
That's an interesting question, that they've come to that conclusion. I think one of the other reasons, Chris, that they're coming to that conclusion has to do with the interplay between this case and the special counsel regulations. Special counsel regulations say at the conclusion of the special counsel's work, they are to deliver a report to the Attorney General. We're all familiar with what those reports look like, be it from Robert Hur or from Robert Mueller, who earlier investigated this same president. But usually those reports are generated when the investigation and the prosecutions come to a close. It may be that one of the reasons they reach that determination is that until and unless these cases are over, Jack Smith doesn't feel comfortable releasing the reports in compliance with those regulations, and he very much wants to release those reports before he leaves. Why does he want to do that? Because he understands that on January 20th at noon, if he has not resigned and released the reports by then, the new administration has no interest either in letting him continue his work, because the Attorney General can fire him. And if the report's not out, they can ensure that it never sees the light of day, because, again, it's up to the Attorney General whether to release Jack Smith's report, which we understand is likely information, to the public.
Okay, Paul, so I want to get your overall reaction to this, but also I want to remind people that the indictment mentions 6 unnamed co-conspirators. So the question also remains what happens there, but give us your take.
Well, since the co-conspirators were unindicted, they haven't formally been charged with their crime. So presumably investigations and prosecutions of them could continue. But look, with regard to Donald Trump, make no mistake, Donald Trump won. He beat his case with an assist from the Supreme Court of the United States. And it's possible that the case will be dismissed without prejudice, meaning that if it overcomes statute of limitation concerns, it might be brought again in the future after Trump leaves office. But Chris, here's what I think is likely to happen. Donald Trump can pardon himself while he's in office. Can a president pardon himself is a question that the Supreme Court has never answered. The Constitution gives the president broad pardon powers, and we know how friendly the Supreme Court is to the power of the executive, including the president. So I would expect that at some point in the next 4 years, either early in his term or on the last day, one of Donald Trump's pardons will be to himself, thus setting up yet another Supreme Court case regarding Donald Trump.